How about now? Yes. I think it's visible now. Can you see it now? Is it visible? Okay, awesome. Awesome. Okay, so today we'll be doing an introduction to arrest and bail protocols. And I'll be taking the first session today. We have Mr. Other facilitators. See one of our facilitators here, Mr. Uche Naamulu, and His Worship Chief Magistrate Musa Eneye will be joining us tomorrow for the concluding session. And today we'll start by looking at the foundational basis, the historical antecedents of arrests. Now, arrests is a tool, is one of the tools that of law enforcement. And I find that it is also one of the most misunderstood tools, and it is one of the most abused tools in Nigeria today, which accounts for the interesting situation that we find ourselves in, where many Nigerians are afraid to even walk into detention centers. For the purpose of this conversation, I will be referring to, I might say police, or I might refer to a specific agency, but as a general rule, I think tomorrow we will break down some of the common attitudes of different agencies, or some of the common challenges that lawyers face from the feedback we have received from duty solicitors and colleagues. We'll break down some of the common challenges that people face when interacting with various law enforcement agencies. But for the purpose of this conversation, we're talking about arrest in the context of any agency that has the power to arrest and detain. So that we may say police in some cases, we may say law enforcement, but it still speaks to all agencies that have the power to arrest and detain. And in Nigeria today, that includes, now it even includes, someone was telling me about this CJTF, the Civilian Joint Task Force, and the attempts to arrest. But we'll see that when it comes to the power of arrest, anyone can actually arrest. We all have, every Nigerian, if you look at the provisions of the ACJA, when we get to that stage, you'll see that every Nigerian has the same power of arrest as the police, particularly when talking about arrest without warrant. But we'll get to that, so we don't jump ahead. I want us to start with a definition. And one of the best definitions I've seen for what an arrest is a definition given by a UK court in Holgate Mohammed against Duke. It was adopted by the Supreme Court, Nigerian Supreme Court. And in a nutshell, arrest is defined as the act of taking a person into custody in response to a suspicion or allegation that the person has committed a crime for the purpose of bringing that person before a court. So arrest is the taking of a person into custody in response to a suspicion or allegation that the person has committed a crime for the purpose of bringing that person before a court. I'll quickly break down that definition into about 3 or 4 components. So number one, an arrest involves taking a person into custody. In fact, the language that was used in that case was that the arrestor would place their hand on the person being arrested. And you see that language reflected in the ACJA and the ACJL, which provide that the person arresting shall touch the body of the person being arrested, or the suspect. Now, in relation to the use of handcuffs and restraints, ACJA provides that once there is compliance, once the suspect or the person being arrested complies, either by word or by deed, so by word or by conduct, complies with the arrest, then there's no need to put that person, to restrain that person, by use of handcuffs or other forms of restraint. But what it means is that, number one, the person who is arrested is taken into custody by the person arrested. And number two, the second element here is in response to a suspicion or allegation that the person has committed a crime. And then, for the purpose of bringing that person before a court, we'll look at this in a little more detail later. The second quote that I would like to share with us is taken from Olufumilaya and Ubuntu. And the court held that it is the duty of the police to investigate a matter upon receiving a complaint. And such investigation may or may not lead to an arrest. Now, what does this mean? What it means, in essence, is that there's a distinction between investigation and arrest. There's a clear distinction. In Nigeria today, we'll look at the historical, we'll do some history, and then explain why many law enforcement agencies misunderstand the scope of their powers of arrest and detention. But we'll look at that shortly. So the police has a duty to investigate. They don't have a duty to arrest. But once the investigation leads to the establishment of suspicion, or what you may call reasonable suspicion, then, of course, an arrest may be triggered. But then the purpose of arrest is to bring the person arrested before a court. That's the primary purpose. Okay, so what this tells us, what these two definitions tell us, is that one, arrest is a procedural tool whose purpose is to secure the presence of a suspect in the criminal justice system, usually and oftentimes before a court of law, court of competent jurisdiction. In other words, the purpose of arrest is to ensure that the suspect, and the word suspect is used very deliberately, that the suspect is made available to a court. So that is the ordinary and basic purpose of the fundamental purpose of arrest. Now, in practice, however, in Nigeria, we find that arrest oftentimes functions or is abused and functions as an investigative tool or investigative shortcut where detention is used to substitute or is substituted for proper investigation. And every one of us can tell, in fact, I opened by talking about a situation where we have a former attorney general who is currently facing being tried or being prosecuted. And according to news reports, in one instance, one of the prosecuting agencies that arrested that attorney general asked for time to investigate the offense that the person was arrested for. And you wonder, why would you, if you haven't investigated the offense, how then do you know where does the right to what triggered the arrest power, the exercise of that power? And it is an abuse. Whenever an arrest precedes investigation, that is an abuse of the power of arrest. And in fact, that arrest becomes illegal and unlawful. It can be attacked in court and set aside by the court. In practice, we also see that arrest is used as a tool of coercion to force people into doing whatever it is. And I was recently in a well, with a law enforcement agency, and in which were before the head of that agency. And the issue was some of the officers claimed that they had settled, quote unquote, in inverted commas, settled the dispute between a complainant, a nominal complainant, and the quote unquote suspects. And we'll look at the situations where law enforcement agencies get involved in civil disputes, that abuse. But suspects were brought before this and the very senior officers were telling the head of the institution that, sir, we settled the matter. And then the man said, if that all the parties even signed undertaking, they signed an agreement. And the man said, if you had settled the matter, why did they go to Brekete family to tell the whole world that, this our agency is intimidating or harassing them? So clearly, and I said, and he asked me, he said, "Oh, barrister, is what I said wrong?" And I said, no, that clearly, the the police or this law enforcement agency has no business, mediating or settling scores, and there's no basis for people to sit down to start writing agreements, before this agency. But what had happened was that these people were told, if you don't sign, if you don't agree, we will detain you. And that immediately vitiates the consensus ad idem, one of the critical requirements for any contract, that the parties to that contract must be of one mind. You've robbed one party of, of their consent effectively. So arrest is used as coercive leverage tool. And sometimes the person may not even be detained beyond 24 hours or even up to 24 hours. But the mere fact that a person is kept in detention, even if it is for 1 minute, there is an abuse. Of course, the arrest is used as a reputational weapon that is deployed to resolve all manner of conflicts, landlord and tenant, business conflicts, family conflicts. And unfortunately, arrest is also used as a revenue generating opportunity. So arrest is abuse, and arrest is one of the most, I would say it is one of the most powerful forms of state power. It's not the most, it is one of the most powerful forms of state power. And the reason is because of all the state has several coercive powers. And of all the coercive powers of the state, arrest is one of the most invasive because it allows government to physically restrain the liberty of the person, to isolate the suspect from their family and support networks, to control everything, to control their access to information, their access to daily life, to everything, and to also shape the narrative of the alleged offense, because a suspect who is in detention cannot speak to the circumstances of that offense. And it is because of these reasons that modern criminal law places several strong limitations on the power of arrest. Now, the objective of any criminal justice system is to balance at least two competing interests. And if you remember the dictum of the late great Justice Chukwudifo Okuta in the locus classicus case of Josiah and the state, Justice Okuta said that justice is not a two-way traffic, but it's actually a three-way traffic, a three-way street. So you have justice for the state, justice for the defendant, and justice for the victim, in that case, for the deceased. But with regards to arrests, there are two, or at least two, competing interests that have to be balanced. And in today's world, we operate a victim-based or victim-oriented or survivor-oriented justice system. So it should actually be three competing interests. So number one, you have the state's interest to investigate crime, to maintain public order, and to prosecute offenders. You have the individual's interest to their liberty, to their dignity, and to protection from abuse of power. And I would say, thirdly, you have the right of the survivor or the victim to also the protection of the law, and in some cases, with regards to under the ACJA, to compensation, and if possible, restitution as much as possible. So arrest law exists to mediate this, to serve as a mediator, between all these tensions. Now, why is this important? This conversation is very important for a lot of reasons. But I think the first reason is that by definition, I would say, or from a first principles point of view, most criminal cases are either won or lost at the stage of arrest, long before, much longer, long before the matter even goes to court. And why is this so? Because unlawful arrest may invalidate any subsequent detention. A person who is a suspect who is arrested unlawfully and is released by a court may tamper with evidence that would alter the outcome of the case. And then an unlawful arrest or an improper arrest may also, an improper arrest may strengthen a fundamental rights claim. In fact, if you look at sections 34 and 35, you find that any person who is unlawfully arrested and unduly detained is entitled, at the very least, to an apology. So imagine that you have a situation, we'll talk about detention, because the constitutional standards, what the Constitution defines as a reasonable time, is 24 hours, where there's a court within 40-kilometer radius of the detention center, or 48 hours. And we find that unfortunately, we don't have data. But from an anecdotal point of view, you can easily tell that the vast majority of law enforcement agencies in Nigeria violate this very basic constitutional right. In some cases, some agencies will arrest a person and then grant what they call administrative bail, which has a maximum of 48-hour limit. And the grant, they will place some onerous conditions. The Constitution does not allow them. If the person is unable to meet bail, they must release the person unconditionally, or subject to whatever conditions the person can meet, which underscores why arrest as a tool is a very blunt tool for law enforcement to use. We'll look at that, because the purpose of arrest is to bring that person before a court. So the presumption is that, and in most cases, the investigation has been concluded, and then as a result of the investigation, you have identified a person who is a suspect against whom a reasonable suspicion exists. And then it is then that person is then arrested and then taken to the court for their trial. Early legal intervention, of course, may secure immediate bail. And I should also say that one of the biggest challenges that we have in Nigerian criminal law is that most of our arresting of our law enforcement agencies rely primarily on statements. The evidence, what they call investigation, is rarely actual investigation in the sense of forensic investigation. What we find is that the investigation consists of inviting parties, taking statements, quote unquote, under caution, whatever that means, taking statements, and then arresting or threatening to arrest the people who have made statements, and then telling them keep coming back. So in Nigeria, for example, you end up paying, an incident can occur in Lagos, is reported in Abuja, then a defendant or somebody, a party is invited to Abuja from Lagos. You spend your money to transport yourself either by road, by air, by sea, or by spirit, by spiritual means, by whatever means you can afford. Transport yourself to Abuja, probably pay for accommodation, and then submit yourself to a law enforcement agency so that they can arrest you. It beggars, it is crazy. It's not done. It is a huge abuse. And one of the reasons is because we don't interrogate the fundamentals or the foundations of arrest. So a defense lawyer who understands how arrest works can often solve many problems before litigation begins. And I mean, if you don't mind, I will share some anecdotes. I recall I went with a client to a formation of one law enforcement agency. I went to the high-profile client, and the person was told to make a statement under caution. Unfortunately, because of the shortcuts in teaching law, this particular agency, most agencies, when they hear caution, what they think is, when you say caution, that person is being arrested. But the caution actually refers to the words of caution that are taken from the Esperanzo Miranda case, our so-called Miranda rights, which are embodied and encapsulated in the Administration of Criminal Justice Act and the laws. Now, I was saying that in this particular case, but when the person is read their rights, it doesn't presuppose that the person is under arrest. It's just informing them of their rights, that anything they say can and may be used against them. They have the right to a lawyer. They have the right to remain silent. We'll discuss that during a later session, because even our law enforcement agencies know that everyone has the right to remain silent. But if you choose to exercise that right, many of them don't understand that when they tell you you have the right, you actually have that right. So we'll come to that later. But as I was saying, so this person was told, "Oh, we're going to be taking your statement under caution," and I knew that they don't understand. I had. Okay. So I said to the person, I said, "Look, the strongest weapon that a prosecutor can wield in court is a statement that is made voluntarily." Even the Supreme Court said that a confessional statement that is made voluntarily, that the court can convict on the strength of that statement alone. So I said to the person, if you tell somebody, you're telling someone that as you're making a statement, we'll arrest you. I asked him, I said, do you think that statement is being made willingly or voluntarily? The person said no. So I said, okay, why not ask the person to make their statement without the caution? Just tell the person, make your statement freely. And then you can take that statement and do with it, as you will. And the person said, okay. In fact, the head of that unit said, wow, he never knew that since the lawyer is here, the lawyer can also indicate that the statement was made voluntarily. And the person, the head of that, the superior officer, or the officer in charge, then directed his juniors to take the person's statement without caution. And they were confused. They said, how do you mean we're taking it without caution? You could see it's called cognitive dissonance. They were experiencing cognitive dissonance. And I said, your guy said to take the statement without caution. They said, yes, but if we do that, that means we can't arrest. And I said, a statement under caution a statement that is not made, that is made without a caution, is that voluntary? He said, yes. And I said, why don't you want a voluntary statement? Wouldn't you want, if the matter goes to court, wouldn't you want to be able to tender a voluntary statement in court? And that was how that issue was resolved. The person was not arrested. But it demonstrates for me how the vast, the amount of ignorance and the misunderstanding that our law enforcement agencies have of these elementary, basic, and foundational principles of arrest. So it demonstrates that very, very, very serious gap. And this is one of the reasons why you hear today that our detention centers are overfilled with people. In fact, I heard 70% of those in detention centers are actually awaiting trial or undergoing trial, which is a huge problem. It means that there are people there in detention who have no business being there. So a defense lawyer who understands how arrest works can help solve problems before they even begin. Now, from a historical point of view, the current criminal justice system that we operate is not ours. It does not belong to us. It's not natural to this environment. In fact, interestingly, you'll be surprised to know that it is not natural in the place that we copied it from. Because in the UK uses an unwritten criminal law, but we use a codified criminal law. There was a whole debate on codification. The Benthamites, some people were for codification, some people were against codification. For whatever reason, codification was adopted in the colonies, the British colonies. That is how we have a codified criminal law. But the people that gave us the criminal law do not have a codified criminal law. But that's not the purpose of this conversation. For purposes of to understand how we got here, why we are here, it's important to understand the history of policing in Nigeria. The colonial objective of policing was not the protection of citizens. The primary objective of colonial policing in Nigeria was not to protect our citizens. In fact, I wrote an article, I did some research some years ago, and I think last year, so I wrote an article on the colonial foundation, the basis of our criminal jurisprudence, our criminal codes, both the criminal code and the penal code. And interestingly, we say we're taught in law school that our criminal code is based on the Australian penal code, the Australian criminal code, both our criminal and penal codes. Now, many of us do not know that Australia was actually a penal colony. In other words, Australia was a destination where the UK would send criminals, very hardened criminals that they did not want in the UK. So they would, once convicted, they would be sent to do hard labor in these colonies to develop the place. And so the Australian Criminal Code was actually made for criminals and aborigines. The aborigines were those who are native to Australia. So the Australian Criminal Code was made for criminals and aborigines. It wasn't made for a citizenry or for a state-based, it wasn't made for full human beings, compos mentis. And it is that criminal code that was taken. It was actually written primarily by Sir, I think his name was Sir Robert Fitzgerald, was one of the primary drafters, and he's one of those who believed in a concept that they called it, I forget the name, I'll remember, but what they did was they supplanted, it's a transfer of cultures, like a cultural transfer. And so they took elements of the British culture and supplanted it to replace elements of our own culture, which is why you find offenses like bigamy that are antithetical to many of our traditional ways of life. And, you find an offense like wandering, for example. And if you think about it, if a rich man is taking a stroll, if you see a rich man on the road at 12 midnight, that person is taking a stroll. If you see a poor man on the road at 12 midnight, that person is wandering and is liable to arrest and detention and prosecution. So the point here is that the objective of colonial policing in Nigeria was not to protect citizens. It was, number one, to maintain imperial authority, which is why if you look at the criminal codes and even the penal codes, you'll see offenses like contempt of officer, or the abuse of colonial uniform. You see some very funny offenses like that, because the objective was to maintain imperial authority, one, to suppress resistance by the anti-colonial elements, to protect the economic interests of the colonial powers, and then to control our populations using small administrative structures. So if you think about the police in that historical point of view, you understand why the police authority at the time they had broad powers, and their powers were generally very coercive. So they were forceful. Next slide. Now, under the colonial administration, arrest served many functions. So the suppression of dissent. There are the cases of, who was it, Herbert Macaulay, who was arrested. Sir Herbert Macaulay, who was arrested. Many of the anti-colonialists were arrested several times for no reason at all, beyond suppressing dissent. Preventive detention of suspected agitators. Arrest was used to enforce tax and labor policies and to maintain order in trading and mining zones. So we see that the arrests were generally used primarily as a tool of law enforcement without judicial oversight, or with minimal judicial oversight by the colonial administration. So that's I try to abridge, but in a very short nutshell, in a very tight nutshell, demonstrate our colonial heritage. But our colonial heritage, in that sense, is not complete without also highlighting the influence of the English common law on our laws, on the laws that we use today. Because in addition to our inheritance of the colonial laws, we also adopted the common law, and the common law stays with us till today. So Nigeria inherited most of our arrest doctrine comes from, as it has their roots in English common law principles. And of course, what this has done is it has softened the edge, or softened the blow, or the sharp, blunt blow of the colonial dispensation. And some of these principles include, number one, arrests upon reasonable suspicion of felony, or upon reasonable suspicion. Under the common law, constables had the power to arrest with warrant or without warrant under certain circumstances. That is also translated. We find that contained in the ACJA and the ACJLs. In fact, what a lot of people don't realize is that, again, using anecdotal evidence, the vast majority, I would say maybe up to 80% of cases, of cases of arrest in Nigeria occur when people voluntarily walk into the offices of these law enforcement agencies. And what does that mean? It means that essentially that person is arrested without a warrant And that's a problem because the first rule of arrest is that, one of the first rules that govern arrest is that all arrests must be by warrant. By a warrant, and a warrant issued by a court of competent jurisdiction. Then the exception to the rule now is that in certain specific circumstances, an arrest can be effected without a warrant, but it is limited to those very specific circumstances, and which include in a situation where a crime is committed in the presence of law enforcement officers, and so on and so forth, or for the purpose of restraining a fleeing suspect, and so on. But the interesting thing is that under the ACJA, police officers, the power of the police and law enforcement agencies to arrest without warrant is the same power that a citizen has to arrest without a warrant. It's the same power that a magistrate has to arrest without a warrant. But we'll come to that. So one of the common law principles that we have adopted is the authority to detain suspects pending investigation. And usually that's involved physical detention while waiting. But of course, for constitutional purposes, the power to detain has been limited to a very narrow time frame. And this is because many of the English law safeguards developed over time. Unfortunately, we have not had, our society is not as old as the English society in terms of the development of our laws as a country. And so many of these safeguards, which were introduced into Nigerian law, were imported effectively into our law. And it explains one of the reasons why there's a culture, there's a culture shock, if you may, or a discrepancy between what is actually carried out in practice and what you have on the books. It also explains why a lot of our law enforcement agencies or agents actually do not really understand what is contained or what the law says today. Let's see. So in Nigeria today, what is the law? The law today is that constitutional safeguards govern arrests. And these constitutional safeguards have expanded significantly since independence. Secondly, that we practice what is called a human rights-oriented or a rights-oriented criminal justice system, under which the protections, human rights protections, have increased significantly, especially under democratic governments. For the purpose of procedural, a change of procedural paradigm, the ACJA and ACJL were introduced to drive home or to provide tangible breakdowns of the constitutional freedoms that had already been granted. For example, the right to a lawyer of your choice, or the right to fair hearing, for example, and to prepare a defense, Section 36, is broken down into many bits under the ACJA that include the right to a lawyer, the right to be informed of the offense for which you are arrested. In other words, if still just to piggyback or to reinforce this, if there is no offense that the person is being arrested for, then you cannot be arrested. That arrest is illegal. So in the absence of a reasonable suspicion, which we'll look at shortly, there shouldn't be an arrest. So ACJA, ACJL introduced some procedural reforms to change the philosophy of our criminal justice system from a retributive philosophy, which is what was the primary outlook of the colonial system, to a reformative, to include reformation as an outcome. And there are many reasons. The reform, I think ACJA ACJA did 10 years last year, but interestingly, we find that some common examples of abuse of arrest powers today include the tendency to arrest first and investigate later. Once a person is arrested, there's a presumption that that person is suspected of having committed an offense. And before you can suspect that somebody has committed an offense, you must have at least the existence of the mental element, the mental ingredient of that offense, and the appearance of the physical element of that offense. In the absence of any mental or physical element, that arrest is illegal. So the tendency to arrest first and investigate later is an abuse. The use of detention as leverage in disputes is also a very common abuse. And then the assumption that suspects must prove innocence. In fact, I think the general saying is that now who, if I may use this colloquial, now who report first be the victim. So you see situations where a landlord and tenant who are engaged in a tenancy dispute will be brought, or a landlord will be taken to the police station and told that he or she is a suspect, and detained for asking or for demanding rent. And a demand for rent to be construed as, what's that thing that they like to use? As a threat, threat to life. Threat to life. I once told a defaulting tenant that we'll do everything we can to obtain the rent within the ambit of the law. And the tenant asked me, "Is that a threat?" And I said, "Yes, that is a threat. It is a threat to use the law to achieve or to recover possession and the arrears of rent. It's not a threat to life." So in Nigeria today, the power of arrest is often abused. And the two key instruments that regulate the power of arrest in Nigeria today are the Constitution of the Federal Republic of Nigeria, particularly Chapter 4, and the Administration of Criminal Justice Act. And in the case of states, the Administration of Criminal Justice Law of the state. For the purpose of this discussion, we will look at the constitutional architect that secures or protects personal liberty. The constitutional architecture, that protects personal liberty. And you find these in sections 35 and 36. And what I find in practice is that most times when lawyers tend to challenge illegal detention, we sort of have we experience tunnel vision because we think of the detention and not the arrest. But in most cases, well, for the purpose of this conversation, the detention cannot occur without the arrest. And so what that means is that immediately a person is placed under arrested, their constitutional rights become operative. And so this means, for example, that we should start talking about constitutional rights at the station. I want to highlight here that if we also take a look at, if you understand the nature of the profession that we are in, as lawyers, we are barristers and solicitors, which means we occupy two different functions. We are barristers who go to courts and file applications in court, conduct trials in court, and we're also solicitors. A solicitor does not go to court. A solicitor takes instructions from a client and instructs a barrister who will go to court. So if you think about these two roles, you understand that the temperament of a barrister is very different from the temperament of a solicitor. And in fact, the reason why we call the PDSS the Police Duty Solicitor Scheme is because the scheme is for solicitors. It is the solicitor who goes to the police station to take the instruction from the client. And the temperament of a solicitor is calm. A solicitor is expected to be calm and to not to be temperamental. If you think about it, you can't move motions or make arguments and submissions in a police station. So the temperament that is required for us to do our work when we're interacting or interfacing with law enforcement agencies, we find is the temperament of a solicitor and not that of a barrister. That's just a side comment. So immediately a person is detained, then the rights to personal liberty are triggered. And Section 35 establishes the right to personal liberty. I like sometimes the way we frame our laws in Nigeria can be a little tricky. With law, you start from the general rule and you move to the exception. Unfortunately, we find that in the ACJA and in many ACJLs, I think Lagos State was the first to enact its Administration of Criminal Justice Law, 2007 or so. But you find that sometimes the wording of the sections frame, we'll look at this in specific detail, but the wordings of the section frame the section starting with the exception and then it moves to the rule. And I'll give some very, very quick examples. A very quick example is with arrests. And you find the ACJA says that, just give me a second, let me see if I can pull that up. But the ACJA, if I may paraphrase, tells us that unless a person, it says, let me pull that up. You have three elements at play. The first element is placing your hand on the person who is to be arrested. The second element is restraining the person who is arrested, whether the person should be restrained. And the third element is the submission by the person who is being restrained, whether that person submits to the custody. So you have a situation where if the person submits to custody, then there's no need for a restraint. But the way the section is worded in such a way, in fact, in a very confusing way. It's worded in a very confusing way. And it is confusing because the placing of a restraint, let me see, the arrest is made by touching or confining the body of the person unless the person submits to custody by word or action. Let's read it. Read it out for us here. In making an arrest, the police officer or other person making the arrest shall actually touch or confine the body of the person to be arrested, unless there is a submission to the custody by word or action. So we see that if there's a submission to custody by word or action, then there is no need to place the arrest. So the question is, which is the default position? I'll leave that to just agitate our minds a little. But what we see here is that when the exception is stated as the general rule, it creates all manner of problems. So as a general rule, liberty is the default state. Our default position is liberty. And so any detention or a derogation of the right to personal liberty is an exception to the rule, to the default rule. And what this means is that the state has a burden to justify any restriction or derogation from the right to personal liberty. Now, again, I was saying that if we understand how the rule and the exception should flow, it makes it easy. It makes it much easier to appreciate the way the law should operate. But most times, what happens is that in practice, we find that the logic is reversed. And oftentimes, detention is often the starting point for most investigations, which should not be. I think I've highlighted that. Now, what are some of the lawful exceptions? Under what circumstances can the right to personal liberty be derogated from? So Section 35 allows special circumstances. And these include, one, arrest upon reasonable suspicion of committing a criminal offense. What does this mean? It means that you don't arrest someone because a petition was made against them. And the only way that you can know whether the information in a petition is true or not is after an investigation has been committed. So arrest upon reasonable suspicion, the execution of a lawful court order, which is often a warrant, and then detention for the purpose of bringing a person before a court, and then lawful imprisonment after conviction. So we see in all these cases that immediately an arrest happens, there's a clock that starts to count. And that is one of the reasons why arrest is a very blunt tool, because it has very limited use by law enforcement. Now, looking at the phrase reasonable suspicion, this phrase is very, very, very important because it is the foundation, it is what grounds arrest, it is what grounds the power of the law enforcement agency to, excuse me, to actually conduct an arrest. So it means that in the absence of a reasonable suspicion that the person has committed an offense, then that law enforcement agency does not have the power to effect an arrest. Okay, now let me so what does reasonable suspicion mean? And we find that a lot of the time our law enforcement agencies actually abuse this idea of reasonable suspicion. Why? Because you hear things like, if you tell them, well, this matter is a civil matter, it's not a criminal matter, they will tell you, we'll look at some of these excuses, they'll tell you there's an element of criminality, whatever that means, that they're investigating the element of criminality in the claim or in the petition. But you can actually investigate without arresting. You can investigate without arresting. So reasonable suspicion requires that, number one, if the incident came by way of a complaint, that one, there must have been credible witness information that a crime actually was committed. 2, there must be direct observation by the police officer, by the law enforcement agent of criminal conduct. Or 3, there has to be physical evidence linking the suspect to the alleged offense. Because until that person is suspected, then, or in the absence of any suspicion, that person cannot be categorized or classified as a suspect. But what we find in practice is that the arrest will occur based on complaints by individuals who may either be influential or may have influenced the agencies, or arrests may be triggered by commercial disputes framed as criminal matters. Or there may even be vague allegations lacking evidentiary support. And I saw a case where somebody was invited and was told that there was a petition against him that he had committed an offense. And we said, okay, petition that the person has committed an offense. What's the offense? And they said the offense is that he has committed, is suspected of committing an offense. And we said, yes, we understand that, but what is the offense? He said the offense is that he's suspected of committing an offense. You know, and you can see how that logic becomes circular very fast. Becomes very circular. So in practice, reasonable suspicion, the standard of reasonable suspicion requires that an investigation must have been conducted and that the investigation has shown or demonstrated that some of the elements of the offense have been established. So we would say easily that a prima facie case exists. Prima facie case is said to exist. Now, I'm not sure, are we all together? I hope we're all together and I'm not talking to myself. Are we all together? Please share. Okay, can you hear me? Yes, oh, great. Okay, I'm rounding up now. So, what is reasonable suspicion? I think just to emphasize, reasonable suspicion is a belief that is based on facts. Is a belief based on facts. And I think we had established that previously. Let's see. Okay, and established that. So what we want to do now is to look at in sequence what should the process look like after a complaint is made. What should the process look like to ensure that the right of a Nigerians are protected. And I think to highlight this point, I would say that I have the opportunity sometimes of conducting trainings with law enforcement agencies, and you find it's very interesting. And this point also could be a little disturbing, but you find that to a large extent, many law enforcement agents, actually do not know what rights exist in Chapter 4 of the Constitution. So there's this game that we play, and we would say, let me see if I can. I want to try something. Okay. With your permission, can we pause recording? Okay. So Okay, so I can say this freely. Yeah, so there's this game that we play, and or that I designed, and I'll ask the law enforcement agents to mention the fundamental rights that they know one after the other, and to list them out, one after the other in sequence. And what you find surprisingly is that once somebody says, and the game is you can't repeat what someone has already said, and you must say something new. But once you hear right to life, maybe fair hearing, and maybe right to, they'll say freedom of religion, but it's actually freedom of thought, conscience, and religion. But once you pass these three, everybody is stuck. So you have a situation where maybe a room full of about 50 to 100 law enforcement agents, cannot go beyond three fundamental rights. And that is very serious. It underscores the need for training among them, because what you see is that, first of all, can you protect something that you don't even know exists? How do you do that? So there's a huge problem. And so it is imperative. I mean, that's another conversation it's a conversation for another day. But, if imagine that you're working with somebody who does not know what these rights are and does not understand the framework, on which these rights operate. It shows that you may be having two different conversations, or a different conversation, which explains sometimes the tension and the conflict between lawyers and some law enforcement agents. Okay, so we've talked about reasonable suspicion. Now, what are some of the ways the ACJ 8 provides, as an extension of Section 35, that no person shall be arrested merely on a civil wrong or contract? And you find that this is one of the most violated rules in Nigerian criminal law. And how is a matter? How do we know if a matter is civil? A matter is civil if it involves a debt, a business dispute, land quarrel, rents, bride price issues. You will find, it's okay, I think we can resume recording now. Bride price issues, partnership disputes, and so on. Family quarrels, demand for refund of money, and so on. All these matters belong in civil courts and not police station, not the police stations, and not EFCC, not law enforcement. And I'll tell you, as lawyers, we should have serious conversations among ourselves. Every time a lawyer writes a petition that converts a civil matter into a criminal, with the objective of perverting the criminal justice process, what happens is that you are devaluing the value of the services that we offer. Because what we're saying, in essence, to our clients is that your solution lies with the police and not in the court, not in the civil court. From a risk management point of view, that is actually very risky behavior. We're undermining our profession by ourselves. And it's little wonder that you find that people would rather go to some social justice works, this internet, what they call them, these vigilantes, social media vigilantes. I don't want to mention any names, but we all know them. And the irony is that what these guys do, some of them have a very basic understanding of law enforcement. They will still go write a petition, still follow the same process that the average person could use. But then on top of it, they now add a layer of cyberbullying and social media callouts and all that. But anyway, make sure that the issue is civil. Now, what you will hear is sometimes is that, there's an element of criminality inside, and so on and so forth. There are many ways that these things play out. But if we understand arrest law it is easier to have a conversation as a solicitor, not as a barrister. I heard a case where a lawyer recently, got into an altercation, a shouting match with a police officer, and of course, it led to an assault, and the lawyer was arrested. Nobody wants that. I'm sure when His Worship addresses us tomorrow, he will share some of the mistakes that lawyers make, when in this process, when we're trying to secure the release of our clients. Just to bring everything back, I had mentioned that before we can say that a reasonable suspicion exists, there must have been an investigation. An investigation involves a number of things: interviewing complainants, inspecting documents, collecting statements, visiting the scene. Under the Police Act and even the ACJA, a police officer is supposed to visit the scene, because in most cases, in most crimes, the vast majority of most of the evidence is actually at the scene of the crime. Excuse me. Verifying claims, determining whether a criminal offense exists, and so on and so forth. And the purpose of all of this is to avoid illegal arrests or wrongful arrests, because an arrest without prior investigation automatically creates wrongful arrests, wrongful detention, abuse of rights. It affects the confessions. It leads to the collapse of the case, public complaints, and officer liability. And this is why, at the beginning, I had said that in many cases, most cases actually are lost at the point of arrest from the beginning, whether or not the officer is aware. And, unfortunately, the prosecutor does not have a say at the beginning. Most prosecutors don't even know what transpired. All they have to go by is the information in the case file. All they have to go by is the information in the case file. And in situations where law enforcement agents try to create or criminalize civil matters, it helps. Again, like I said, an understanding of arrest law helps them, and it's important for many of them. It is important sometimes you have to explain to many of them that, look, there's a difference between somebody's conduct may be immoral. Somebody may have taken money from another person, for a business transaction. And then if the transaction went south, stop taking the person's calls. Yes, not taking the calls of your creditors is bad behavior. It may be immoral, but it is not the same thing as, it doesn't equate criminal intent. It's not the same standard. It's not the same standard at all. The standard for criminal intent is very different. And you find that many investigators also do not use, when investigating, they don't work with the elements of the offense. I've talked about that earlier. I think this is a very good point for us to pause. And I don't know if there are any questions at this point, but I think we can pause for today. Are there any questions? I'm happy to take questions. I see as we are nearing time for prayer, yes, the materials will be available. So we'll share the link for feedback and for us to share our emails as well. Does anyone have any questions? I think I'm done at this point. So just to wrap it up, the reasonable suspicion is a threshold that the Constitution places for a violation of the right to personal liberty. My objective in this session was to take us on a historical journey through the origins of our criminal jurisprudence, our criminal law, to the situation that we have today and the standard for the basis of arrests and detention, and particularly under the ACJA, how the ACJA and ACJL contain domestications of constitutional provisions. I remember in court, we filed a fundamental rights enforcement matter against an agency, and one of the lawyers that agency he accosted me and said, oh, that we just mentioned some fundamental rights, but I was referencing ACJA. And I was trying to tell him that, yes, I referenced ACJA because the ACJA provides domesticated versions and broken down versions of our constitutional rights, of the provisions in the Constitution. So I think I have done my bit. So thank you, everyone. I don't know if there are any questions. I would hand over the mic to our able moderator. Tomorrow, we continue tomorrow. Esther, I believe you're still with us?
Yes, sir. Yes,
okay,
I
so
am.
we don't have to arrest this.
No problem, sir. That was a very enriching and eye-opening discussion you led, understanding a lot of things about how our law enforcement works, and most especially how to work with them when you make the distinction between a barrister and a solicitor, and the demeanor to have when we're at law enforcement agencies. So that was a very, again, enriching session. I have I have a question because it's something that happened. So so if a friend was arrested on a Friday evening, and I think it was a deliberate effort to arrest her on a Friday evening. So when we got to the police station, we're trying to negotiate for her bail and everything. And they said that, oh, it was the weekend, they couldn't do anything. I just want to ask if the weekend counts in that 48-hour period where they are supposed to either um, charge her to court or release her, because by the time we wanted to file a fundamental human rights matter on Monday that, oh, they kept her and everything. We was not saying that, oh no, it was the weekend doesn't count. So that's my question, basically.
I'm sorry, Esther, the line was breaking. Could you please repeat the question?
So I said my friend was arrested, someone I know rather was arrested on a Friday evening. She was arrested, her place of work made a complaint on a Friday evening, and they arrested her on a Friday evening and kept her Friday, Saturday, Sunday. So by Monday, when we went for the bail on Saturday, while we're trying to get them to release her and everything, they were saying that, oh, it's the weekend, they cannot do anything, IPO is not around. So by Monday, when we were interested in filing a fundamental human rights, they were not like, oh, it was the weekend. The weekend doesn't count when you are counting the 48-hour period that they're supposed to have done reasonable investigation to let her go. So that's my question actually. When does the weekend count when you are when you are counting that period, so when they're supposed to keep someone and when they're supposed to have released them?
Oh yes, the weekend counts by all means. In fact, what the constitutional standard is very, very strict. And people are arrested, people commit crimes on Saturdays and Sundays. Law enforcement doesn't go to sleep because it's it's weekend or because it's night. So the fact that a person can be arrested on a Saturday means the person can be released on a Saturday and on a Sunday. But for Sundays, for administrative, there are some places, for example, where for administrative purposes, the officer who is responsible may not be available. But as a general rule, you count every day. Under the Interpretation Act, I know there's a formula, a procedure for calculating um, what happens when a day on which an act is to be done falls on a public holiday or a non-juridical day. But in my opinion, that doesn't apply here because people can be released on Sundays and on Saturdays. I think in the FCT, I think the FCT is very lucky in the sense that because of the use of this magistrate oversight function, and his worship will tell us some of the experiences. In fact, I recall many years ago accompanying a magistrate to a very notorious station in Abuja at the time. And while we were, the DPO, the DPO took us into his office and brought drinks. And his worship said, no, we're not here to drink, that we just want to observe your detention areas, and then look at your lists and all that. But while we were being served drinks in the DPO's office, some of the people that had been detained for long were being released through the back door. They were taken out. Over time, those practices, have reduced. And what you find today, to a large extent in the FCT, is that many of these stations, when somebody is arrested and maybe the person who is pushing or instigating the arrest, is insisting that the person should be arrested, what they do is they just charge the person. They say, we charge you to court after 24 hours or 48 hours. But it creates a problem for our criminal justice system because here you have somebody who was arrested at the will of another person, and not on the basis of an establishment of a prima facie case or reasonable suspicion. That is a problem. Now you've charged the person to court. For what? For what offense? How do you prove that offense? Then you have a situation where people now start going to court, for how many years or for months and weeks. They're going to court to answer questions that they have no business answering. And the prosecution will keep telling the court that our witness, no this, no that. Or they will tender the person's statement as if they really tendered evidence, when in reality, a statement is just a statement. If it's not a confessional statement that complies with the provisions of the ACJA, it doesn't bear much weight, unless you can link it to the elements of the offense. So I would say for the purpose of calculating the 24 hours, the 48 hours, weekends are inclusive, in my opinion.
Okay.
To answer your question.
Thank you, sir.
Thank you for that question, Esther. Just to quickly announce that the link for the CLE points is in the chat. Dami, please, can you help us repost so we can fill it? Any other questions? In the absence of, I know once we've done the rituals of CLE, I'm sure there's no need for anyone to stay in the room. But I think that I saw a raised hand. Esther. I saw a raised hand, Mr. Obi Anoye. So please, Mr. Obi.
Ms. Dami would have to unmute.
Have a question?
First.
You can unmute now. maybe he didn't intend to. Was it for a question? Okay. So in the absence of any questions, I look forward to seeing everyone tomorrow. Tomorrow I'll be primarily a participant once again. And we'll have Mr. Uchenna Amulu and to worship Rebu, Chief Magistrate Musa Ene as our resource persons. So in the absence of any other business, on behalf of the committee, I would like to say the CLE committee, I'd like to say a big thank you to everyone. I saw Mr. Babatunde Tijani. I'm not sure if he's still here, but is there anyone, any member of the DSS want to say anything? Or do we?
Hello, sir. Can I still ask my question or my intervention?
Oh, yes, please, Mr. Yes, your intervention. Yes,
yes,
go
sir.
ahead.
I am on all first with you that there shouldn't be this matter of today is weekend, today is Saturday, because I'm sure that the DPO or whoever, if he has somebody in the hospital and the doctor says they won't treat on Saturday or Sunday, that he should come on Monday, it wouldn't be a nice thing to hear. There are some jobs that are sensitive that you do not want to see what we call key man risk in an organization. That is where Mr. Okeke is not available, everything will stall. There must be an alternative person that will do the job, especially when rights restriction is involved. That's my point. But another one I want to find out, that interaction you had with the prosecution lawyer regarding fundamental action and ACJ provisions. I didn't quite get what the objection was and how you resolve it.
Thank you, Mr. Obi. That was an excellent intervention. Thank you so much for that. I agree with you that, as you said, in fact, many police stations, many DPOs, the irony is that the funny thing is that many of them don't even get subventions, to run the stations. So for a lot of them, especially when IPOs are investigating cases that involve indigent persons, the IPOs themselves are responsible for feeding and taking care of those people. So as you said, to avoid a key man risk scenario, in fact, if you look at the provisions of the Anti-Torture Act, Section 7, the person in charge, the officer in charge of a detention center where torture is carried out, or where certain activities are carried out, is held liable and responsible. So there is always that. So it is important. I think there is a staffing issue, there are logistical issues. There are stations that you will go to, or commands, like for the police now, that you go to where, you'll find officers working even on weekends actively, covering the essential roles. I understand that correctional services, if an order from a court for bail is produced at a correctional center on a Sunday, that person will be released on that Sunday. Unfortunately, we have situations where some of the more problematic agencies, I won't mention any names, will tell you that they don't work on Saturdays and Sundays. That's a huge problem. Now, with regards to the incident with the prosecution lawyer filed, as part of their response to our fundamental rights application, they argued that we did not demonstrate the breach of a fundamental right as provided for in Chapter 4. And as such, the court should strike out our fundamental rights application. You know, and that is one of the objections to an FHR application, which is that, oh, this matter is actually not fundamental rights. It is something else. It may be matrimonial causes, but you are framing matrimonial causes as a fundamental right. But the person's argument was that because we cited, we were arguing on the premise of provisions of ACJA, that ACJA is not constitution. And I said that was kind of weak. So my explanation was that provisions of ACJA are actually domestications of constitutional provisions. And so, yes, and so when we're arguing that a person should not be detained for a civil matter or a contract, it is an offshoot of Section 35. And so we are still arguing Section 35, but we may not say Section 35. It's actually Section 35.
Okay.
You know, and the court agreed with us, you know, that those provisions are actually statutory reenactments or statutory domestications of the constitutional provisions.
So to strengthen what you have in the Constitution, or actual demonstration of what we have in the Constitution.
It demonstrates, yes, to demonstrate in an operational form what we have in the Constitution.
Okay.
That's correct, sir.
That's great. Thank you, sir.
Thank you very much, sir. Yes.
My pleasure. My pleasure.
Thank you so much. Okay, in the absence of any intervention, I think interventions are welcome as well. Somebody mentioned that the link isn't working. Doctor, maybe if you could try a different browser. I'm not sure. Browser. Please try a different browser. Okay. Okay. I trust everyone has filled the form. So I was asking if there's anyone from the Duty Solicitors branch who would like to say something. In the absence of any of them. Victor Chair, I see Mr. Diron, Oladiran Falore. I greet you, sir. Mr. Latunji Atoebi, former secretary, former YLF chair, former this, former that, future everything. Yeah, welcome, sir. I see Doshima. You're welcome. Okay. So thank you very much, everyone. I trust everyone has filled the form now. So I wish everyone a pleasant evening. Do enjoy the rest of your day. Over to our host. I guess we can call it a day. We resume tomorrow. Thank you very much, everyone. Mr. Amachundi David, the IP people, I greet you. I missed you earlier.